Good morning, good afternoon, and good evening. Welcome to Course 2A of the Monique and Roland Vale People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy of International Law and member of the Bureau of the International Association of Democratic Lawyers. In Course 1, we presented the history of the United Nations Charter and the contradictions within it, the prohibition on the use of force as applied to the genocide in Gaza, the right to peace, and the responsibility to protect. We discussed using the Charter to litigate and organize in support of people's struggles, and we examined the illegality of Israel's assault on Gaza and litigation about the illegality of the Iraq War. Our topic for today is the United Nations International Court of Justice and compliance with international law. Our faculty for this course includes John Quigley and Nidia Diaz, and I will also be making some remarks. Each of them will speak for about 40 minutes, and I will make a few comments. We will have questions and answers with the people who are registered. We have French, Spanish, and English. Well, actually, we have Spanish and English translation today, and you can see the little box at the bottom and choose your preferred language. And if you have questions, please put them in the Q&A box for our discussion later. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, which is peoplesacademy.net. Our first faculty member is John Quigley. John is a member of the Scientific Advisory Committee of the People's Academy of International Law. He is Professor of Law Emeritus at Moritz College of Law, The Ohio State University in Columbus, Ohio, in the United States. John's published writings include the Genocide Convention and International Law Analysis and The Ruses for War, American Intervention since World War II. John served as advocate in the International Court of Justice in the case of Bosnia versus Serbia. On the issue of Palestine, he has served as expert witness in the Federal Court of Canada, as lecturer at the United Nations and at the Royal Institute for Strategic Studies, and as a consultant in Palestine-Israel negotiations. On Palestine, John has written The Case for Palestine, an International Law Perspective, The Statehood of Palestine, International Law in the Middle East Conflict, The Six-Day War and Israeli Self-Defense, The International Diplomacy of Israel's Founders' Deception at the United Nations in the Quest for Palestine, The Legality of a Jewish State, a Century of Debate over Rights in Palestine, and Britain and its Mandate over Palestine, Legal Chicanery on a World Stage. Our next faculty member is Nidia Diaz. Nidia is a lawyer, advisor, and lecturer in the Republic of El Salvador. She was a founder and historical activist of the Farabundo Martí Front for the National Liberation, FMLN, and was appointed guerrilla commander. She is Comandante Nidia Diaz. As part of the Dialogue Negotiation Commission of the FMLN, Nidia participated in negotiations with the Salvadoran government. She was a signatory to the peace agreement in 1992. Since then, Nidia has participated in the monitoring, implementation, and construction of the peace agreements. She took part in the founding of the FMLN political party. Between 1994 and 2021, Nidia served in its national leadership. She was Deputy General Coordinator, International Relations Secretariat, and National Secretary of the FMLN's Historical Memory, and was part of several national campaign commands. She has served 5 terms as a deputy to the Legislative Assembly of El Salvador. In 1985, Nidia was wounded and captured in combat by a Cuban-American CIA advisor, Felix Rodriguez. She spent 6 months in prison, and she was exchanged by humanitarian agreement, along with other prisoners, for the daughter of President Duarte. Her book, called I Was Never Alone, documents her experience. Nidia is currently responsible for international relations of the Association of American Jurists, AAJ, El Salvador branch, and a member of the Advisory Council of the AAJ, as well as advisor to the AAJ Honduras branch. She is also currently a member of the Secretariat of the Anti-Imperialist International of the People in Defense of Humanity and Nature. So John Quigley will start. John?
Thank you very much. That was quite an introduction for Nidia Diaz. I hope our listeners understand the importance that she had in the whole picture in El Salvador. As it happens, I negotiated with the Minister of Defense back at that time to try to get permission for exit from the country of wounded FMLN fighters who were not able to go into government hospitals for fear of being killed. But in any event, I hope you'll pay close attention to her. Now, what I want to speak about is the judicial apparatus in the United Nations. And this fits in very nicely with the presentations from the previous session of the Academy, which focused on the UN Charter and War and Peace. The idea of having a court was actually put into operation because it was thought that having a court would be a way to prevent war. And to understand this, one has to go back to the time of the League of Nations after World War I, because that is when this court was founded. The court that presently exists under the United Nations, the International Court of Justice, owes its origin to a court that was established under the League of Nations in 1922, a court that was called Permanent Court of International Justice. So if you see that term, Permanent Court of International Justice, it refers to a court that existed under the League of Nations. And as I say, the idea for that court was that if states could be convinced to solve their differences by law, through international law in a judicial setting, that would keep them from going to war. Now, that may sound like a naive idea, perhaps it was, but that was the origin of the court, a court that you will sometimes see referred to as World Court. There is actually no such entity as World Court, but that term is often used to refer to the court of both the League of Nations and the United Nations, since they have slightly different names. But in any event, the International Court of Justice is one of the principal organs of the United Nations that is provided for in the Charter of the United Nations. That charter is a document that you can easily access on the internet. In fact, all of the documents I'll be talking about can be accessed quite easily. But with the Permanent Court of International Justice, the idea, as I say, was to prevent war. An initial idea was that the states that we would become party to the League of Nations, members of the League of Nations, that any of the disputes they might have with other states would go to the Permanent Court of International Justice. As it turned out, states were not willing to allow that kind of jurisdiction. That is, states wanted to have more control before they could be taken to the Permanent Court of International Justice as a defendant. So a procedure was developed for the Permanent Court, a procedure which continues now under the International Court of Justice, whereby there would be 3 different ways in which a case would fall under the jurisdiction of the court. One would be if the parties agreed once the dispute arose that the case would go to the court. So that is a possibility. That is, when a dispute arises, the parties can agree that it should be resolved by law, and that would give jurisdiction to the Permanent Court, or now the International Court. A second is that they could make a declaration in advance of any dispute arising, a declaration in which they would say that they agree to be sued by any state that has an allegation against them under international law, and that they would agree that that case could go to the Permanent Court, and that they would be bound by the decision. So that was a second procedure. And as it turned out, it was not used very much because states were not willing to submit themselves to the jurisdiction of the court so broadly. The third way, and this is the most important, the third way was that there could be individual treaties in which the parties would agree to certain obligations, and that the treaty would have a provision in which the states agreed that any breach that is alleged could be taken to the Permanent Court. And all 3 of these methods have been carried over, as I say, into the International Court of Justice. So the case that you have heard about that is presently before the International Court of Justice, brought by the Republic of South Africa against Israel, that case is brought under a treaty, namely the Genocide Convention, the Convention on the Prohibition of the Prevention and Prohibition of the Crime of Genocide. That treaty has a provision that says that in case of an allegation by one party against another, the matter can go to the International Court of Justice. And that is the basis on which the Republic of South Africa was able to gain jurisdiction over Israel. Israel clearly did not want the case to go to the International Court of Justice, so it would not have agreed with the Republic of South Africa to submit the case. However, Israel is a party to the Genocide Convention, as is the Republic of South Africa. So that means that any state that is a party can sue any other state in the International Court of Justice. So that is the technical avenue that has resulted in the court having jurisdiction over that case. Now, you may have heard that it is permissible for states, when they become a party to a multilateral treaty, that is a treaty with a multiplicity of parties, it is permitted to file what are called reservations to particular provisions. Many states that are party to the Genocide Convention have filed a reservation to the provision that calls for jurisdiction in the International Court of Justice. The United States, for example, when it became a party, filed a reservation to that provision. That means that the United States cannot be sued for genocide in the International Court of Justice unless the United States agrees with the state that wants to sue it. So that means that in this present case brought by the Republic of South Africa over genocide in Gaza, it is not open to the Republic of South Africa to sue the United States for complicity in that genocide. And that is because the United States has filed a reservation to the provision that calls for jurisdiction in the court. It's possible for states that have filed a reservation to withdraw the reservation. So in principle, it would be possible that the United States could withdraw that reservation and then it could be sued. But that is not happening and is not likely to happen. A reservation needs to be filed at the time a state becomes a party to a treaty. So it is not open to Israel, for example, to file a reservation to that clause now. It did not file such a reservation when it became a party, so it cannot subsequently file such a reservation. So that is how this case gets into the court. The matter is a bit more complex than what I have just indicated, in that typically in the International Court of Justice, a case will be filed by a state that considers that it has been injured by a breach on the part of another party. In the case of the Republic of South Africa suing Israel, the Republic of South Africa is not alleging that it is a party to the convention in a way that makes it injured by virtue of what has been done by Israel. So the case is being brought on a different theory, and that is that any state that is party to the Genocide Convention may bring a case against any other party, even if the state bringing the case is not itself injured. And the rationale for that principle is that with the Genocide Convention, the obligation not to commit genocide is an obligation that is owed to every other state that is party to the Genocide Convention. That means that South Africa, even though it has not been injured by what Israel is doing in Gaza, can bring a case to get the court to rule that Israel is committing genocide in Gaza. And in doing this, in bringing the case that way, the Republic of South Africa was operating on the basis of a precedent in the court that involves a case brought by the Gambia against Myanmar, alleging genocide in Myanmar. That case was filed several years ago by the Gambia against Myanmar, even though the Gambia is not injured by the alleged violations being committed by Myanmar, which are internal against the Rohingya population of Myanmar. But Gambia was entitled to bring the case simply because Gambia is a party to the Genocide Convention, as is Myanmar. Therefore, it is open to the Gambia to bring a case. So the Republic of South Africa was aware of that precedent and decided to use it on the same rationale, namely that South Africa is a party to the Genocide Convention. Therefore, the obligation of Israel not to commit genocide is an obligation that is owed to all other state parties, including South Africa. So that is how that case can get into the court. Now, Israel argued, if you watch the hearings that were screened on the case now about 3 weeks ago, Israel argued that even though a state that is non-injured may sue, nonetheless, there has to be a dispute between the state that sues and the other state. And Israel said there was no dispute between South Africa and Israel. If you watch the hearings, this was the principal legal defense that was made by Israel. The court, however, decided that there is a dispute on the basis that Israel had made complaints to Israel about the actions in Gaza, that South Africa characterized what Israel was doing as genocide, that Israel replied and denied that it was committing genocide, and therefore there was a dispute. So this term dispute is an important technical term, and it is used in the clause in the Genocide Convention that provides for jurisdiction in the International Court. In particular, that clause says disputes are subject to the court if they relate to the Genocide Convention. So the court decided provisionally that there is jurisdiction. Now that will be raised again, I imagine, by Israel. The court issued a preliminary order against Israel saying that it should not commit genocide while the case is pending. The case will now move to a phase that is called the merits, where South Africa will file a memorial, a document in which it explains its case. At that point, it will be open to Israel to file an objection to jurisdiction, and I suspect that Israel will take advantage of that possibility and will object to jurisdiction, and it will argue again that there is no dispute between South Africa and Israel. So that will be open to the court then to make a final decision on whether there is jurisdiction. If the court decides that there is jurisdiction, then the state of Israel will file its memorial in which it presents its arguments on the merits, in which it will argue that it has not committed genocide. I'm not sure exactly how it will frame that argument, but that will be its argument. And from there, the case will go to oral hearings, and then the decision will be made by the court in a judgment that it will issue. And all of that will take several years. Now, the fact that all of that takes several years puts great importance on the order that was just issued in the case, which is, as I say, a preliminary order. So it's not based on a definite finding that Israel has committed genocide, but only that South Africa has been able to make a plausible case that genocide is being committed. That is what is required before the court can issue a preliminary order. The idea of a preliminary order is that the court can order a defendant state to act in such a way that it will preserve the status quo pending the decision on the merits. That is, that the defendant state will not act to make the situation worse while the case is pending. So that is what the court issued, saying essentially that Israel should not kill Palestinians while the case is pending. And the court took that language from its own preliminary order in the Gambia case. So if you look at the order that the court issued in the Gambia case, it said that the government of Myanmar should not kill while the case is pending, should not kill Rohingya. And the court simply copied that language and put it into its order in the South Africa case to say that Israel should not kill in Gaza while the case is pending. As you probably know, Israel has continued to kill, so it is in violation of that order. It is up to the Security Council to enforce an order of the court. That matter has been referred by the court to the Security Council, and so far the Security Council has failed to take any action, and that is because of the fact that the United States, as a permanent member of the Security Council, will not allow the Security Council to take any enforcement action. But I wanted to say all this simply to give you the background for the case that is in the court now. Some people have asked the question, why is it that South Africa chose genocide as the basis for the suit? Why didn't it sue Israel for violating the laws of warfare, for engaging in bombardment that was aimed at civilians, clearly a violation of international law? Why didn't South Africa sue for that? The answer is that there is no treaty on the law of war that provides for jurisdiction in the International Court of Justice. You may have heard of the Geneva Conventions of 1949, which do impose limits on states when they use military force, that they're not supposed to target civilians. They're not supposed to target even military objectives if it would impact unnecessarily the lives of civilians. So there is a treaty on that subject, but that treaty does not have a clause that provides for jurisdiction in the International Court of Justice. So it would not be open to South Africa to sue under the Geneva Conventions. This is a reflection of the great limitation one finds on the role of the International Court of Justice in resolving matters that relate to warfare. If you go back to what I said about the permanent court during the time of the League of Nations, that the idea was to have states going into court rather than engaging in warfare. This has not been carried through very effectively because there is no treaty on the law of war. There is, for example, no treaty against aggression that provides for jurisdiction in the International Court of Justice in case of a breach. There is no treaty on international humanitarian law, the rules that relate to what a state does during a war. No such treaty that provides for jurisdiction in the International Court of Justice. So for the lawyers of South Africa, the only choice they had was either to file no suit at all or to sue under the Genocide Convention. Now, it is their position that they have a solid case under the Genocide Convention on the basis that the Genocide Convention prohibits creating a situation in which a population will not be able to sustain itself. And that is rather clearly what Israel did by the evacuation orders that it issued to the population of Gaza, telling the population to move around to different places when there was clearly no way that the population could sustain itself in the places to which they would go. So that is the basis for South Africa's case. South Africa also has to deal with a clause in the Genocide Convention that says there must be an intent to destroy a population or a portion of the population. And South Africa has a very plausible case here because if a state creates conditions that are calculated to bring about the destruction, which is clearly what Israel has done, it rather obviously has an intent to destroy at least a portion of the population. So Israel would seem not to have any significant defense. What it has said so far is that its action in Gaza was aimed at defending Israel, but that is not a valid response to an allegation of genocide. Even if Israel has the right to take the action that it is taking in Israel, in Gaza, which I think it does not, it still would not be able to commit genocide. So I think we should now go to a few questions that we'll have time for.
Yes, thank you so much, John. I think that you answered a lot of questions that people have been asking and set a really important context for the case we're seeing now pending in the International Court of Justice against Israel. John is going to have to leave at the top of the hour to teach a class, so we are taking questions to John a little bit out of order. And John, there are a couple of questions in the Q&A that you may want to address. I'll just, there, 2 or 3 of them, I'll just mention them and then you can field them how you will. First of all, can NGOs, non-governmental organizations, file amicus briefs in the International Court of Justice? Secondly, since the UN filed a reservation to jurisdiction in the ICJ, how can the US be held accountable for its complicity in genocide? And then the third is, didn't the court's orders say that Israel can't kill Gazans with genocidal intent? Not just that they can't kill Gazans, but they can't kill Gazans with genocidal intent.
Okay, NGOs can file. The court will entertain a submission from NGOs. It does not become part of the official record of the case, so the court does not have to pay attention to what is filed by a non-governmental organization, but it is permitted. The second question was, again, what? Yeah, yes, whether the United States could be brought into the court. As I said before, the answer is no. So unfortunately, there's no way that the court can be would have jurisdiction to sue the United States. There is a lawsuit that has been filed in the United States for complicity in genocide. That case has so far been dismissed by a federal court in the United States. But that is still a possibility. Then there's a very important question about the content of the order. I said that the order says that Israel should not kill, and the question is, does that not mean only that Israel is being ordered not to kill with genocidal intent? Well, I think that Israel is alleging that there is genocidal intent. And I think for purposes of this order, and this now goes back to what was ordered in the Myanmar case, for purposes of this order, the court is saying, do not kill, full stop. And then we will decide eventually whether the killing was genocidal or not. But for now, stop killing, because continuing to kill simply exacerbates the conflict? But that's a very good question. And other international lawyers would probably disagree with what I have just said, but that is the way I read it, in particular by going back to what was said in the Myanmar case, which was clearly, I think, an order to the Myanmar government not to kill Rohingya, period.
John, there's one more question, and that is, what is the implication of the court not ordering a ceasefire?
The court did not order a ceasefire. I think its view is that Israel could stop committing genocide without a complete withdrawal, so long as it stopped killing people, so that a withdrawal would not be necessary for Israel in order to stop committing genocide. A further problem is that the court could not order a ceasefire in the sense that it has no jurisdiction over Hamas. So a ceasefire implies that both sides would stop fighting. So in principle, the court, I think, could have ordered a withdrawal. I don't think it could have ordered a ceasefire, even though that was the terminology that was being used by South Africa. South Africa was asking for a ceasefire. South Africa used that terminology, but I think what South Africa was really asking for was a withdrawal. And the court's view was that that was not necessary for Israel to stop committing genocide. That view was questioned by the foreign minister of South Africa, who held a press conference and said, the only way to stop the genocide is for Israel to withdraw. But the court did not accept that argument.
John, if we can just squeeze two more questions in here. Doesn't the Genocide Convention allow for other states to prosecute U.S. officials under universal jurisdiction? And since Israel's violating the provisional measures, can South Africa now come back and ask the court to order a ceasefire?
Well, universal jurisdiction allows for cases to be filed in a domestic court. Universal jurisdiction has nothing to do with the International Court of Justice. But in answer to the question, yes, it is open to states under their domestic criminal law to file a case, a prosecution against particular Israeli officials, not against the state of Israel as such, but against Israeli officials who are responsible for committing genocide. So that is open actually to the courts of any country in the world to do.
And also, under universal jurisdiction, other countries could prosecute U.S. leaders for complicity in genocide or aiding and abetting genocide.
That is correct. They could do that. Their laws on genocide probably provide for commission either directly or through complicity.
Can South Africa now ask the ICJ for anything more, such as for Israel to stop the bombing and shelling of Gaza and stop dynamiting buildings?
Yes. When a state like South Africa gains a provisional order, it can go back and ask for a new order if the order is being violated. I was one of the lawyers representing Bosnia in 1993 in the International Court of Justice for genocide that was being committed against the Bosnian population. The court issued a preliminary order. That order was not complied with, and we filed an additional request, and the court issued a second order, in effect, reaffirming its original order and calling for compliance. So that could clearly be done by South Africa.
Thank you so much, John. Do you have any closing remarks before you go teach your class?
Good. No, thank you very much. I think this is a very important issue, and I hope we've covered the basics. I should say that everyone should become accustomed to finding the documents that relate to these matters, and they're all very easy to find. The Genocide Convention, for example, to know who is a party, to know who has a reservation. You can Google UN Secretariat treaties, and you'll find a website that gives you all that information. But it's very important to find this information for yourself, because there is much false information that one finds on the internet, and you need to go to primary sources. But with that, I will thank everyone for their attention.
Thank you so much, John. That was excellent. And everybody, I'm sure, really appreciates it and puts into context what we're seeing right now in this landmark case. Thank you. Now, next, we are going to hear from Nidia Diaz. Nidia?
Thanks a lot. I'm going to be starting now. Hello? Hello, everyone? Good afternoon. Thank you for inviting me to be here. I'm going to do a brief of some political issues that can give you a little more context about the things I'm going to be presenting today. Any questions? We're going to make sure that we can actually at the end. I'm going to be then looking at the guide of a slide deck. Great. The negotiation of peace in El Salvador.
Happening?
We're going to...
Okay, all right, that's fine.
Oh. Can you hear me? So we can go to the next slide. Next slide, please. Okay, we're good. So what happened previous to the Civil War in El Salvador? We can find some of the main reasons. If we go to the historical process in El Salvador, we consider different levels and the phases. There's a series of different that accumulate based on economic and social issues that make that at the end of the 19th, during that crisis period, we have an explosion in El Salvador in 1932, and the reason for that insurrection and indigenous and farmers, we say how lands were being taken away from the people that were doing many of the agricultural work, and the farmers and those who did the coffee. Also because there was a worldwide depression and there was a lack of employment in all these in these areas. And also there was a dictatorship at the end of 1931 when the vice president and there is a coup d'etat that happens, and there was a democratic socialist that was and a Maximiliano Hernández Martina that actually does the coup d'etat and then becomes a president. That year we have the elections on the 1st of January, and they steal that win. It was the first time the Communist Party that was founded in 1930. Days afterwards, people get then captured, like Farabundo Martí was actually captured on the 20th of January, and 2 days after the farm insurrection. That was the first instance in we see in terms of their 30,000 indigenous people were murdered and hanged in the west part, and that's how that dictatorship then started. That lasts 60 years. That it goes through different stages. That is very important to point out that, but the regime of Maximiliano Martinez was 14 years, last 14 years, by imposing himself in an election where he actually prohibited the in different constitutions to have another election. So the origin of when did this happen in the 1970, when we see two big floods in 1972 and 1970 that actually makes all the social forces were actually getting against the military government, and the first instance in 1972 they actually raised up and were trying, and those who participated in exile, and we see a situation in which against all freedoms during that time we see a higher depression, and in 1977 we see the repression. There were massacres that happened during February 8th that we see it in our history. We have been seeing a series of massacres and disappearances from 1977 and 79. Carlos Humberto Rivera, the dictator, governed by a state of exception. He suspends all civil guarantees, and then there's another coup d'etat where we actually see the proclaim a new reform. We nationalized the bank and coffee. There's actually a series of measures that there was actually supported by Carter, United States, who had actually stopped the help to El Salvador because of human violations. But this lasts very little, because in the 80s, another group of military, Duarte comes back from exile and creates the board of the military cycle. It becomes another hand of the dictatorship, and it's the year there have when they kill Oscar Romero and different people, democratic leaders, and the persecution of the church becomes stronger, and they see many alliances and composition. And then the Democratic Front is born in April because of all this later. The guerrilla forces that actually began in the 70s have been part of the social fights and struggles, but it was not generalized with against then the another guerrilla, Salvador Martí front, and they become allied with other and with the Democratic Revolutionary Front, and that alliance then the proclamation of Democratic Revolutionary Government, and they create political commission and diplomatic to get out of the designated conflict. At the moment, the Republican win the election, Reagan, he said that there's no political out, the oligarchy and the pro-oligarchy and the pro-imperial. So there is no way. So all ways of creating a way of discussion, understanding, that was recognized later during the negotiation process by the president back then in 1991, who said a new end during an assembly during the peace declaration, saying that the war was not an invention or a part of as against West. That was the vision before. The El Salvador war was a product between the war between the United States and USSR, called back then, and it was then recognized who was part of the oligarchy, and he actually had to find this peace treaty. And the war was the inability of those who had the power back then. They do not create a dialogue or understanding venue. In 1981, at the beginning of 1981, they gave a militaristic response, is to destroy those rebel forces. That we have more than 70,000 dead during those time, accumulated during the period of, in the sense that more than 8,000 disappeared. There's at least 6,000 incarcerated. There's a lot of persecution, and many people that were exiled were sent into exile. And there's a lot of people that migrated. And the process of migration is something also that we can talk about later, but this conditions created that burst, generated the beginning of that war. It was that accumulation, accrual of victims that are then revealed, and everybody thought that was going to be me and myself, something that was going to happen really quick, that was going to be able to open talks and dialogues, but that was not right. What Reagan did was military out and wait. So the factor that continue to prolong this process is the interest of the military forces. We see the same year of January of 1981. Month later, in August, was the Franco-Mexican declaration, with these two governments, French and Mexican government, recognize the FML is the voice of the people, and without it, there's no solution. And the other thing that they recognize and talked on this, that we had to humanize that conflict. In that Franco-Mexican declaration, where 27th of August 1981, all the countries joined, and that became a factor that helped. And the United Nations in that same year, in 1981, on the 4th of October, Daniel Ortega read in front of the full assembly the letter for MLA, the Democratic Revolutionary Front, to open the language. But it didn't get any response for the power. So it was in 1984 where the group of, it was all the countries that were third party that were actually working in good faith. There was Panama, Venezuela, Colombia, and Mexico. They created some conditions that allowed to have a dialogue with the recently elected Duarte government, and that was the first dialogue happened in 1984 in a mountain in El Salvador, and one municipality where thousands and thousands of Salvadorans were there, and the international community and the International Red Cross And that had also a third party in the board, the Catholic Church, Archbishop Miguel Idana, that is not, who is known as the peace creator, and also Papa Francisco Gregorio Rosa Chavez, who's been named by the Pope. And in that way, we were talk about the causes of the war, but they show a constitution that was created against insurgencies. And we're in a negotiation. We created 38 reforms, but in the moment, the they actually created the constitution to put we didn't come here to actually to give up. We came here to talk the causes that created the war, militarism, the lack of freedom, and that final dialogue created a continuity that happened next month, where we had a purpose of the constitution to take power away from the military and allow them to do what we wanted, but they asked us. They refused to do that, and then 3 years later, we had a third dialogue with the church and the apostolic conversation. There was two commission. It was interrupted by some murders that happened and killings to the president of human rights. And we stopped speaking from our part. And we didn't reestablish until 1989, when we had another president, Cristiani, and we had offered part of this, or they actually offered during their campaign to have this dialogue, but it was very calculated because there was international pressure on the social Christians to have a ceasefire without any agreements. And that was very hard in October of 1989.
And during that time, ONU was the observer and the Vatican was involved. And there was also always this the church, the Catholic Church was in the third party during conflict. So that was happening when they killed a lot of labor. October 30th, 15 to 20th union members died, and the conversation was paused, and there was no interest until there was a different context. And we launched an offensive November 11, 1989. We changed the correlation of forces, and we began to sit down until there were the management of diplomacy in ONU sat at during the moment that we were being recognized, as I shared at the beginning, by the community international and the Franco-Mexicana, and we implemented the humanization of the conflict. We followed Geneva's process, and we were very respectful during that process, and we had to respond. There's some whole memory written down about the role that was taking place, and also all that it meant with the humanization of the conflict, the treatment of those that were incarcerated, the treatment of those that were injured. All of that was developed, and many organizing organisms of humanity were considered. And then in 89, and after the negotiations of peace, 4 months after the ONU becomes more involved, and the General Secretary at that time contacts a group of countries so they could be in collaboration, plus Spain, and Panama steps out. And so this group of friends was formed by Mexico, Spain, Venezuela, Colombia, friends of the secretary. And they accompany the process that begins April 4th, 1990, with ONU as the third intermediary. And ONU becomes involved in this as observer of this internal conflict, and sometimes even the mediator. And from there, I formed part of the first dialogue, 84. They call it Dialogue de La Palma. I did a follow-up during after dialogue of 87 and dialogue 89 with Cristiani, and 89. I was part of the conditions of negotiation and part of the table talks. In Geneva, we launched the 4 parts of this negotiation over this armed conflict. And these policies were going to overcome whatever the initial causes that generated the civil war. With these agreements that resolved the root causes, was going to create the democracy of the country and the fulfilling of the human rights. And it was giving the product of conciliation of these parties. With these missions, we were there with the support of the ONU being the intermediate. And another important agreement, we were not going to get up no matter what the circumstances were. And if there was any crisis during the negotiation, there was going to be a small committee that was include ONU and discuss how we would overcome. But the agreement was that we will not get up until it was resolved. 2 years of negotiation and without interruption. And this was in the midst of the war, because the war did not stop at all. The war continued, right? And the images that you're currently seeing at this on this slide are the dialogues that we had. We discussed Esquivel's 2 after the counter group. They provided the dialogue during 87. We cannot sign the peace or cease fire without the establishment really of the agreements that we drafted by addressing the root causes. And dialogues got interrupted during 87, during the killings of the leaders of human rights. And after, as I was sharing, next slide, please. So peers can see this. Electoral proposals to postpone elections. We had these dialogues in Costa Rica and Mexico, and these are opened up by Cristiani. In Costa Rica, it was the one for the defense. The previous slide, please, just to see the image. The previous one, please, just to see the image. Oh, actually, I meant forward. We'll go forward. Yes. Yeah. There you go. The offensive, the group of friends of the General Secretariat and the negotiation in Geneva, where the format established the mechanic and the rhythm of timeline. Here you see images during they were accused of favoring the guerrilla, and they were murdered in November. It was a great genocide. We had many guerrilla members that died and were victims as other social fights were. That blood that was shed unfortunately contributed for there to be a negotiation open process in April, as I previously shared with ONU and friend countries. I also was talking about how Geneva built the timeline, the structure, and the construction of process. This is very important because in addition of establishing the objectives and also deciding that we would not get up as delegations, the two delegations, we also created timeline. It was going to be a year of negotiations, and it got extended to 2 years to the position of reform, and we also led consultations with sectors, social sectors, political sectors, and also to support us in defining the agenda, right? We were having consulting. Next slide. The agenda that was established during negotiation was fought for armed force, human rights, judicial system, electoral system, constitutional reform, economic problems were part of the negotiation. These problems that impact the whole country, the whole Salvadorian society. We then talked about the separation of forces, the ENZ and the FLM, and reduction of the FAS. And during the conversion of the FLM into PP, then we shared about the calendar, the verification of agreements of peace that were verified twice under ONU watch, and then there was another organism called PAS, and other agreements that we came to address all the impunity, all the killing during the war. So that is very key, because this same agenda, we had to negotiate it throughout 8 days in Caracas. It was no longer in Geneva, it was in Caracas. And until we came into an agreement, well, the other part, we had a lot of initiative to give proposals. We were the ones that wanted to change the regimen of the country, the states, but others were in opposition. There was a lot of disagreements. And so ONU was in the middle, right? Next slide, please. It is very important that we see that the first agreement related to human rights, July 1990, we arrived to political agreement where we talked about reestablishing the rights of humans and political prisoners, and that there was going to be an area that focused on economical social issues. There were areas that was going to have the departments, social, that made sure that there was not violations. And there was also observers that were ensuring that this agreement was fulfilled. And it was used for continued negotiations. During 91, we're still in the midst of negotiations. we wanted to change articles of the Constitution. We needed two assemblies, one that approves the reform by the majority, and then an initiative that amends that assembly, and the second following one that ratifies that. So we had to make sure that everything that we did was reflected in the policies, the security, safety, the reform that the judicial system saw, and how to elect, and how the characteristics should processes have, and judges are elected. And we also reformed the new constitution that was going to administer, and it was going to have jurisdiction towards the supreme electoral process, and observe these processes. There was a commitment to make sure that electoral process was working and make sure that it's in the defense of the poor. These reforms were mostly political. We did not touch on economical, not that we didn't want to, but it's because there was not enough correlation to be able to do it. In terms of the military, we proposed since the 90s, since our very first meeting after establishing the agenda, we proposed the dissolution of the two military parts, and it's taken on months later after it's proposed. And it was the ONU at some point was discussing this, but then once we were talking about the constitutional reform, we put that to the side, and the assembly that was built in April 91 would propose these reforms and approve reforms, and then once we signed the peace treaty, we would try to find a ratification and begin a new phase once the reformed constitutions were ratified.
So we had some crisis in developing these agreements. It was we were stuck in that process in September of 1991. We couldn't see the end of the road from the government or from the FML. We didn't know where we were going to end up. What was the top until when? What were we going to, what are the limits that we were going to accept? And, there was a very important role that was played by the United Nations. They have been playing some very important roles as proposed in the document of on human right or public security, and those are the mediation issues that come into play. So we were able to, go above that crisis, and we were going to socialism because in a negotiation table, we don't solve the issues of the parties and a revolution. In order to separate a dictatorship and allow us to create political processes that are correlated, and what we're trying to do is end of the military dictatorship and the beginning of a democratic process. And negotiation ended December 31 with all the issues that were brought forth, including the socioeconomic issue. And it was only a platform, a very basic platform. The that was helping us, and that in this field, and was able to create a platform or form to create different sites or aspects that will allow us to do the work, like face poverty. And then at the end of 1991 and 1992 coming in, we had not even finished some of the reorganization of those who were fighting, and the general secretary of the UN said, stop the clock and say we're continuing negotiation. It was until 2 o'clock in the morning until we actually get the agreements that we were able to follow through. And we continue in January, talk the separation of power, the calendar for implementation, organization of the things that need to be done, and also the time of transformation of the political parties. And then in January 16, when then the treaty, the peace treaty was actually, and we can go to the next image, please. And there, the agreement were actually put in play 16th of January. And President Boutros Ghali, who was the first and the next general secretary, he'll be there for 2 years. And then and there were then guarantors, witnesses, Mexico, of the Mexico, Spain, their friends, Colombia and Venezuela. The presidents signed. This was really important. And this is the story of the agreements. From there, you see the enforcement. We see the law of reconciliation, establish the freedom, take people out of the jails because of ideals, political prisoner, all the things that were part of the initial conflict. And the conflict ended on 15th of December of 1992, when it was not reversible to go to the past. All these agreements are going to take us to a democratic process and the end of a military dictatorship. We had started that process in 1982, and we were thinking the military and the new dictator was coming with a reform of the constitutional law. Was this the beginning of a democratic process? So the reconciliation law allow people that were incarcerated to come out. And in 1982, the law was then applied. The form came in 1993, but 3 recommendations came in place on people were actually being being advanced. And these are the responsibility of states or paramilitary groups in terms of death at 2.7% of those people was a responsibility of the guerrilla. And 10%, those are recommendations in terms of the people who were killed. And those people that were named were not able to have a position. And there were recommendations for reparation. And also there were recommendations that everything, there was reparations to all victims, creating then a budget and what percentages are going to be shown. But the Christian government said no, and the military said they would not follow that. The Supreme Court said the magistrate said they would never resign. The front accepted the report and said it could not only follow one part. So when they saw that report, the January recommendation in January of 1982 put it aside. I'm talking about the government back then. And the president presented in Pineda, the total amnesty law for consolidation and peace was pushing all the recommendations of the Truth Commission, and was present in El Salvador to 2016, where it became inconstitutional in 2016, and actually created a new reconciliation law based on the truth and justice and repetition and the work that it that is in a little bit how one, and then in 1993 94, that was the first time we have elections. We have 11 elections since then, after the sign of the peace treaty. This election that we had in 1924 is not done following previous prototypes of elections that would allow frauds and thefts of election. And this is under laws that were derived from the peace treaty, which allowed the current regimen that actually be the winner with clear loss. We are facing difficult time because we still hear the accounts, because there were evidence of some electronic frauds, and also some manual frauds, because we're seeing some of the urns broken through, and we see of the observers have asked, we say paper ballots also thrown around. But we want to make sure that the 10 times that we have participated, 11 times it was in legislative issues, and 7 times in president election. The first years was in dispute because the government with whom we actually signed the peace, the Arena party, won 3 other elections in 1995. They were already a governor in 1995. They had won the 1989 elections. After that, they won 1994. And then after that, 1999. And then after that, 2004, those 4 periods. And there was a commitment with the commission, although the United Nations were looking for this peace treaty of 1992 until 1990. And with different way, the unos are minusa. After that was a team from the Secretary General, and we have a special rapporteur for 1980, and he continued to work until 1997, and that rapporteur, who was the human rights, as we were trying to establish all these agreements, and we're actually educating the population, and we were making sure that all the reforms were being informed, that we're actually create a firm and everlasting peace that we had actually created. But there was a moment in which all political parties were being represented at national, the UN and the Catholic Church and the parties involved, and they were involved in at the table developing the laws that were derived from the Constitution. Institutions will have support from the laws that were created. They were aware, and they were part of the assembly. So these were people that had representation in the legislation and the assembly. And this is how it created some human rights started coming up again in the 90s. I want to know, the friend from Farabundo, Martí, arrives to the government, and 2009 2 period is the party that asked for forgiveness for the power of the government in name of the Salvador state. And start talking to the victim, creates 2 round table for reparation, and the table to find the disappeared children during the armed conflict. And about some as the constructor of peace, it creates some space. And Council Security, Council for Economic Development, and Education Council. In a generate a condition within to create agreement of a second generation. And all the Paris actually are set down as part of the assembly. I'm talking of 2015 to 16. And that starts a new process that create second generation agreements with the support of the United Nations, and with the participation of the El Salvador government that was facilitating, and a group of persons that were civil part of the social Soviet people. No, they were not part of any party, but had a more objective view that were part of this. Of those 180 agreement, Salvador Sanchez as president of the Republic and co-signer of peace was in May of 2019. The government was already went, and he was not willing to follow that agreement. That already the blessings of the UN and had and the very rich experience. The compensate law for health was actually refused. So and no matter what party it was, a party in which he win, and another because the party New Ideas had no representation. We have not been able to implement something to be implemented. Talk about health, economy, education, and strengthen the institution that came from the treaty or other that came up to control transparency, to for example Institute for Public Information, or the Court for Government Ethics. And that's we're trying to create the transparency of peace. When this happened afterwards and with the second agreements.
Now what happens? The narratives regarding the peace agreements saying that the fight it was amongst criminals. They were saying that it was a farce, that this was corrupt process. This narrative interrupts and denies the work by the organisms. It doesn't recognize the work that was done by the participant government parties, the ONU. It denies the whole history of what happened and the roles that each party took during a certain time. And so this serves as a forming of a new narrative that there should be a new democracy in order to violate systematically any agreement of peace, giving the military more roles more than the Constitution itself, not respecting these human rights agreements, even if it receives support. There was an independence that did not came from the administration or from the presidency. It is removed without any constitutional causes. So this instance, so now the group of the counter group and all of these organisms, such as the transparency organisms. So we see the control of the state, neo-fascism processes. So there was times during COVID, there was an implementation of emergency actions There was, as the Constitution shares, there was a very short time where certain things were agreed. We enter a very difficult time where the legislative powers are not respected. It's going to be 4 years where the the president came and authorized a loan related with the territory control. But in reality, there was a pact with gangs, which is proven totally through investigations, including the attorney that was removed because he was running an investigation with this gang pact. And so in 2020 was executive hits. It was censored by the Supreme Court, the international community. 2 years later, once he had contract of the Congress, removes, gives, without any reason, with any constitutional processes, removes certain processes. There are processes that are followed, but it was not. And he was censored. There were new modalities being used. And then there were special experts, resolutions from the Inter-American Court sharing the comments by judges, during those thousands that were captured during 2 years, accused of being part of gangs, were innocent. Out of all of those, many of them were innocent. Some may be members of gangs, but not all of them. There were no processes. There were not any constitutional guarantees. And the international organisms were on top. They showed up to the Geneva meetings, and during other instances, during also economic, social issues, we were living in an economic situation that was the main problem of the people. Before, it was safety, but now there was the continuing of immigration, unemployment that the people faced. But people did say they feel safe, but it was this safety with that was a sense of safety where it didn't have any constitutions respected, and the suspension of this humanity of this regimen was used during the campaign. He asked for the vote from other deputies, and he shared that the other party would release the criminals, and that we would go back to the times of before, something that is so absurd, because of course no one wants to free gang members or people that have not been captured, the white collar workers that after 7 or 8 years they are investigated. And so the white collar people that committed crime should be incarcerated, and the ones that we were demanding to be free were innocent. 7, and there was this article launched, because they were at the wrong place at the wrong time. This is why they were detained. Could you imagine releasing 7,000 people due to being innocent? And under custody, thousands of people have died. And we see this in that Mr. Mason, leader of intelligence, had died due to the torture that he endured because he was a leader in intelligence. And then they inform the family members, oh, this person died. They led a process that should not be done. In 2016, March, the government led by Sanchez presented himself at the international court. And we said, we haven't had a specific law of how we apply the women's statute. There's more than 225 cases. But they have not been considered the children that have died, children of the incarcerated. In 2022, March, we had in the hundreds, and that number has increased more than 70,000 incarcerated under conditions. There's already people facing a lifetime. And it's been 170 years of this incarceration. And maybe they don't say that it's a life in prison, but it is implied. So it is not allowed by law, but it is applied. So he says a lot of people feel safety, and it's his legacy to humanity, since he's the cool president. But the true causes that lead to crime are not observed. There's no human respect. There's so many violations that lead to crime. Where is the reasoning behind this? And during this, so there's also electoral fraud. As I have shared, we have gone through 11 processes of legislative election and city elections and presidential. And we have not seen, since the peace treaty has been signed, such fraud. We call this a virtual fraud because it was an electronic voting system. And it was a digital system where they lost the voting boxes, certain votes. I'm going to share more information about the international organism, part of the Inter-American system, and it's worth taking a look because they're experts in observing and keeping track of other violations that can be sued. And just to conclude, we do not deny that no one denies that he was going to win, but what we don't admit or accept is how the Congress has been from 84 to 60 in the 60s. And he was hoping to get to the low 50s members of Congress, even 40s. And this is a plural representation. The country's Republican, Democrat, but it reflects the plural democracy. And so other parties would run. But now, with this corruption, what he wants is 58 or 59 parliamentary, and that one would be against him in opposition. Due to this system of counting, this began when there couldn't be, when there was reform, and one of them was to reduce deputy members and how he could get fuller control. And so I characterize this as rejecting of the history. And we need to recover that, right? Because the people still in the struggle, they're not passive. They're currently fighting for the small threads of democracy that is left. That way we don't go towards, step further to a neo-fascist system that is based in a neoliberal in favor of oligarchy. As a family, they want to have an oligarchy system. They're all business owners. We don't have anything against business owners or corporations, but they want to violate the people. And we also have populism and the corruption. These are characteristics of this current regimen. But how is this sold or seen in the world? Well, as the cool one, the one that overcame these systematic violations. My people, we were born to fight. We continue to fight, and we continue to face this at the political, jurisdictional, social levels. We face a scarier system because the military that reduced to 20,000 after our processes of fights that we had in El Salvador, and it hadn't been maintained, and it gave power to the civilians. Now it's trying to increase to 40,000 and reduce the safety. And he could reform the constitution and remove anything that he does not like and design it in his own way, getting rid of the fight with so much effort that we led. Let's not talk about the symbolism. Rejecting history can change the curriculums shared at school and change the narrative to see the fights as just a group of criminals, denying the party's participation. As they say, the people come back, and the history is built by the people, from the people's fights. Even if he gets rid of the monuments, even if he destroys them, sets them in fire, even when he even burned the Saint Romero images, he could continue doing it. And we one day will retake the path of history and maintain the memory. That is our work. There's a lot of responsibility for those that try to maintain peace. We have a duty to maintain the historical memory. That way the new generation doesn't believe it. It's the creator of all changes. If we maintain memory, we will not forget where we come from, and we will not commit that error to give power to the armed forces and destroy democracy, because this is a combination of many generations. There's a generation that was born during the war 12 years ago. That's when my son was born. I was pregnant when the war commenced. The people that were born after the peace treaty was signed, the children of the war, and now it's 3 decades after, post, we're 21st century. We are now 4 years into the third decade. How easily that is forgotten. 60 years under dictatorship, but it
Nidia,
is a historical memory. Oh,
Nidia.
I will close here. Thank you
Yes,
so much.
Thank you. Thank you so much, Nidia, for your comprehensive report of the monumental negotiations in El Salvador,
Gracias por tu
role of the UN,
informe
and
integral
the
del papel de El
challenges
Salvador
of
y las naciones y
maintaining
los
peace
desafíos de
and
mantener la paz
justice.
y justicia.
I'm hearing the Spanish
Oh,
interpretation at
sorry.
the same time. I know our interpreters have to leave at the top of the hour. I just want to really thank Nidia for your unique and really dramatic and important presentation. Our next program in the People's Academy will be Course 2B on Thursday, February 22nd. It will cover the organs of the United Nations and structural challenges in utilizing them to support people's struggles. And the faculty will include Kojo Koram, Dinora La Luz, and Naja Ahmad. You will receive notices and a Zoom link for that program. And I want to thank you all for supporting the People's Academy of International Law and helping us to grow and provide high quality programs for progressive and anti-imperialist lawyers and human rights defenders all around the world. See you at our next course.